rule is broader than necessary to exclude those method users who are not actually qualified to work for transit authority. Of course it is broader than necessary because there are substantial number of good method users. I mean, if the goal is to take out only bad ones, right? Your goal is to take out bad ones, but you are taking out everybody, then yes, your action is broader than necessary, right? We may assume not only that this conclusion is correct, but also that it is probably unwise for large employer like transit authority to rely on a general rule instead of individualized consideration of every job applicant. 하급심에서 한 게 다 맞을 수도 있다. 네. 그리고 이렇게 크고 돈이 많은 데는 시간을 들여서 좋은 사람 찾아내야 되는 거 아니냐, 일일이. But these assumptions concern matters of personal policy, do not implicate the principle safeguarded by the Equal Protection Clause. Okay. 하지만 이런 판단은 그냥 인사 정책의 문제다. 네. 그럼 언제만 위헌이냐면 그 밑에 보면 Because it does not circumscribe a class of persons characterized by some unpopular trait or affiliation, it does not create or reflect any special likelihood of bias on the part of the ruling majority. So only when there is a special likelihood of bias on the part of the ruling majority, only when there is such bias, then the 14th Amendment or the Equal Protection Clause will be invoked. Okay, well then, what shall we do? Look at the footnote 39 on page 6, footnote 39. Legislative classifications are valid unless they bear no rational relationship to the state's objectives. Okay, so that's a rational basis review. Right? So, and the court says that, that policy choice is for the policy choice of barring all method and users is for safety and efficiency. And if it's rational, if it's conceivable, if it's rational that, not accepting, if it's rational that barring all methods and users will increase safety and efficiency, if it's rational to think that way, then it is constitutional. That's how low the level of scrutiny is. It doesn't matter whether the state actually achieves the goal. If it's rational to think that the state may achieve the goal of safety and efficiency, then the court will accept it. In the end, it may not, barring all methods and users, may work against safety and efficiency, right? Because, to get the best workforce, you have to have a larger pool, right? But by cutting away methods and users, you are decreasing the applicant pool. The less competition among the applicant pool, the lower quality applicants you will get. So it may work against safety and efficiency. It doesn't matter. Well, unless there is some bias against people, bias against some people with some unpopular trait, will not ask more, will not raise the level of scrutiny, will not raise the level of review, will just do rational-based review. So who are the people with the unpopular trait or affiliation? Minority race and women. Okay? They have not been part of the ruling majority because they, still now in the US, 70% of, not 70%, 90% of senators and 90% of legislators are men. 90% of professors are men, right? Same goes for the race. Blacks and Latinos and Asians make up, less than 5% of legislators, less than 5% of college professors, and other coveted jobs that have influence on the lawmaking, right? That's what the court is saying. That, this is not about women, this is not about gender, so we'll just apply rational-based review. Then, who should decide all this, right? Who should decide that, race is so strongly protected or gender should be so strongly protected? Look at page 523. Case like this reminds us that race is important. Brown versus Board of Education of Topeka. So here there was a segregation at public schools. Public elementary schools and junior elementary schools and high schools. Junior high and senior high. So all 12 years. And the question was, the constitutional challenge was raised against the segregation law. And it was particularly difficult because the law required segregating, didn't require discriminating, right? The law said blacks, colored people and white people should be housed in different schools. Didn't say colored schools will not be given schooling or will not be housed in schools, or will be housed in lesser schools. The law just required separating them, not more.
So is it different schools with same facilities or a same school with different classes of segregated people?
So different schools, right? So if we applied rational-based review, right? Even if it is against race, it could easily be held constitutional. Because, it's rational, right? What could be the state's interest in separating or holding blacks and holding colored people and white people in two different schools? Well, what they proposed back then was the fact that blacks were only recently freed from slavery, and that their level of education was too low compared to the whites, and that they should be given different level of education. They should be all given the same quality education, but at different levels. And hey, that may make sense, right? Trying to teach the students at a level appropriate for their preparedness is one of the ideals of good quality education, right? That's what the segregationists argued. And if you apply the Beezer case, the method and use case, hey, that sounds good, right? It is rational to think that, those things may help the education objectives of the state. But because this is a race, strict scrutiny is applied. Strict scrutiny means not just so strict scrutiny, yes, it means requiring greater governmental interest, but also looking at everything more carefully. And what does the court do? What does the court say? By looking at this more carefully. Sure. On page 16 or page 562, small letter paragraph. Segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of the law. 그러니까 분리수용을 하면서 그 분리수용을 특히 법으로 법제화시켜 놓으면 더 심하다. 왜? The policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of a child to learn. Segregation with the sanction of law has a tendency to retard the educational and mental development of Negro children and to deprive them of some of the benefits they would receive in a racially integrated school system. Whatever may have been the extent of psychological knowledge at the time of Plessy, this finding is amply supported by modern authority. 그리고 그 밑에 이제 각주 11번에 보면은 역사적으로 가장 영향력이 있었던 이 사회학 또는 심리학 그 문건들이 거기 나옵니다. K.B. Clark, Effect of Prejudice and Discrimination on Personality Development. Whitmer and Kotinsky, Personality in the Making. 여기서 이제 실험들을 해요. 그래서 흑인 애들을 데려다 놓고 흑인 인형과 백인 인형을 보여주면서 어느 게 더 좋은 인형 같냐 라고 물어보면 다 백인 인형을 선택을 하고 그 다음에 이제 무자비하게 이제 물어보는 게 그러면 어느 게 더 널 닮았냐 하면 이제 애들이 막 거기서 울고 그런 이제 상황들이 논문을 통해서 정리가 되고 그게 이제 대법원에 제시가 됩니다. 자, okay, so segregation is bad under the strict scrutiny, racial segregation. How about gender segregation? Is there gender segregation? Do you see it? I see one right here in school, well, everywhere in Korea. Bathrooms, right? And also all women's college. There is no all men's college, at least no longer. I went to all men's college. 어디 갔을 것 같아요? No, all men's high school. 옛날엔 과학고등학교가 다 남자만 뽑았어요. 네. But now there's no all men high school, but there is all women high school, and there are all women colleges. How about that? Why is it not unconstitutional? Why is it not presented with a constitutional challenge? Okay. Well, what if they were public schools? You think it should be unconstitutional? Okay. All right. Well, then how about segregated bathrooms? Unconstitutional?
I think not segregating them will be way weirder, I think.
No, some people think that it is unconstitutional. And segregating them, who suffers from segregating?
People who are in between.
And women also suffer because if they build the same number, right, you always see lines and lines of women. So, any argument on that?
The lines, they are not the result of segregation. That's the result of building less toilets for women.
If they build the same number, do you think that the lines will be shorter? I don't think so.
Males just take more time.
No, but I mean, I went to a women's university,
Mhm.
and the sizes of toilets are very different. I mean, there are lots of the in
Toilet.
the women's side, and there's like 2 or 3 in the men's side, and of course, 그러니까 별로 남자 할 거라. 아니 근데 어쨌든 그러니까 여성들이 그런 걸 겪는, 그러니까 둘이 많아지는 거는 세그리게이션 때문이 아니라 그러면 여자를 배려해서 좀 더 많이 놓으면 되는 문제 아닌가요?
Okay. Okay. All right. But still, so why is that okay? segregating?
Because there are present danger of crimes against women, at least in the Korean society.
Okay. Or if you watch the Ally McBeal, 못 봤어요? Ally McBeal? 시대가 달라서 그 얘기도 못하겠네. Well, there's a law firm where they have co-ed restrooms, and that's where they have private conversations, and many dormitories have become co-ed, many college dormitories. Men and women all live on the same floor, use the same bathroom, same shower facilities. I think that there is I think there are reasons, as you said, maybe not just danger, but other reasons that will justify segregation there. But one important reason is this. Look at the smaller paragraph I just read. Segregation of white and colored children has a detrimental effect on the colored children. Why? You just separate them. Why does it have a detrimental effect only on the colored, not on the white? Okay? Why does it have effect only on the colored?
Because there's already noted concept that
they are inferior. Okay. So, if blacks or if the colored people build their own segregated school, right, out of pride, that will not have detrimental effect. And in fact, there are all black colleges in the United States, like Howard College, from which many great people, including Supreme Court justices, have come. So, that's something you should think about. Whether all women's college, even if it's a public, right, will have a detrimental effect to men who cannot get in. You see what I'm saying? If there's an all men's school, public men's school, like Kuocw, which was a great school, by the way, that women cannot get in, will it have detrimental effect on women? Yes, right? They'll feel that they cannot get in because they are part of the inferior group, right? But it doesn't work the other way around. So just think about that. Let's move on. So we talked about race. And now we're going to talk about gender here. Page 714.
질문.
예.
그러면 만약에 남고가 있고 그 남고만 힘든다면은 그게 노출할 수도 있다는 거잖아요. 그거는 그걸 대응하는 여고를 만들어 준다고 해야 되는 게 아니에요.
아니라고 판결하겠죠. 이 논리대로 하면. 왜냐하면 그랬었거든요, 그때. 백인들만 다니는 학교가 있으니까 흑인들 학교는 따로 지어준다. 그거 따로 지었거든요, 실제로. 그 주정부들이. 근데 그렇게 해서도 안 된다라고 판결이 난 거죠.
그럼 더 나아가서 모두에게 초이스를 줘서 인테그레이드도 있고 세퍼레이트도 있다 하면은 그래도 해결이 안 되는 건가요?
그건 이제 그건 어떻게 될지 모르겠어요, 저도. 그런 식으로 해놓으면. 그러면 이제 화장실하고 똑같이 되는 거지. 그죠? 양쪽에 다, 자유롭게 쓸 수 있게, 똑같은 퍼실리티를 만들어주고, 어떤 때는 integrated, co-ed도 있고, 어디는 남성만 쓸 수 있고, 어디는 여성만 쓸 수 있게 돼 있고, 그리고 이제 더 중요한 거는 사실은 이제 더 중요한 거는 여성들이 원해서 그렇게 하는 거라면, 그죠? 또는 차별받는 그룹이 원해서 하는 세그리게이션이라면 다르게 접근하겠죠. Okay, Michael M. versus Sonoma County Superior Court. Very interesting case. Okay. 고맙습니다. 그거 하기 전에 딴 거. 이거 하고 넘어갑시다. Reed versus Reed, 1971. Okay, so this was the first Supreme Court decision to invalidate a gender classification under Equal Protection Clause. 인트레스트가 정당하냐? 그죠? 그리고 그것을 스테이트 인트레스트를 증진시키는 이성적인 방법이냐? 아니 증진시키는 반이성적인 방법만 아니면 되거든요. 네, 이성적이라고 하니까 또 되게 기준이 높아 보이는데 이성에 반하지만 않으면 돼요. 근데 당연히 미리 분쟁의 대상들을 미리 정해놓으면 좁혀놓으면 당연히 분쟁은 더 줄어들겠죠. 네.
여기서는 지금 반이성적이라고 한 건가요? 아니면
여기서는 반이성적이라고 한 거죠. 여기서는 반이성적이라고 했는데 저는 이제 Rational Based Review를 여태까지 아주 낮은 수준의 심사로 유지해온 거에 비춰보면 합헌이 나왔어야 된다라고 생각을 해요. 여기서는 이미 심사 기준을 바꿀 채비가 이미 되었었다라고 생각을 해요. 그러니까 어떤 administrative convenience 이런 거 가지고는 안 된다. 왜냐하면 이게 그 비절 케이스하고 마찬가지거든요. 비절 케이스도 일일이 따져보기 싫다는 거거든요. 메타던 유저가 이 사람이 일을 제대로 할 메타던 유저인지 일을 제대로 못할 메타던 유저인지 그러니까 일을 제대로 할 마약 중독 전 마약 중독자인지 아니면 일을 제대로 못할 전 마약 중독자인지 판단하는데 돈과 비용이 드니까 그냥 전 마약 중독자들은 적어도 일반인들보다는 시험을 패스 못할 가능성이 더 높으니까 이 사람들한테 그냥 안 받겠다. 이래버린 거거든요. 여기도 마찬가지죠. 여성, 남성한테 다 평등하게 기회를 주면 부모 해버리면 부모가 같이 경쟁을 하게 되니까 그걸 그냥 없애기 위해서 그냥 우리는 부친에게 우선권을 주겠다. 그래서 똑같은 기준이라면 이것도 합헌이 나왔어야 된다고 봐요. 네. 근데 여기서는 이미 그 read vs read에서 그런 administrative efficiency, 그러니까 행정적 그 편의 이런 거는 성차별을 정당화할 공익은 되지 않는다라고 판단을 한 걸로 봐야죠. 그걸 어떻게 할 수 있냐면 프론시어러 vs 리찰슨을 보면 돼요. 프론시어러 vs 리찰슨. Okay. Right. Under federal law, male member of the uniformed services could automatically claim his spouse as a dependent, thereby receiving greater quarters allowance and medical benefits. However, female member of the uniformed service could claim comparable benefits only if she demonstrated that her spouse was in fact dependent on her for over half his support. Okay. 그러니까 이제 유니폼 서비스, 이제 뭐 군이나 이제 경찰 중에 유니폼 서비스. 이 중에 결국엔 그 직장에서 혜택을 받는데 그 혜택을 액수를 산정할 때 남자는 여성을 부양가족이라고 써넣기만 하면은 당연히 그냥 부양가족으로, 그러니까 피부양이죠. 피부양가족으로 인정을 해주는데, 여자가 남자를 피부양가족으로 써넣으면 진짜 남자가 일 안 하는 거 맞냐? 남자가 진짜 피부양 상황인지 증명을 해라. 이렇게 돼 있는 법이죠. 왜 이렇게 만들었겠어요? 이 당시에 여성 피부양자가 많았을 것 같아요? 남성 피부양자가 많았을 것 같아요? 여성 피부양자가 많았겠죠. 그러니까 이것도 어떻게 하는 거예요? 그냥 일일이 판단하기 싫으니까 여성은 피부양자로 들어오면 다 인정해주고, 남성은 피부양자로 들어오면은 증명을 하라고 하고, 그렇게 하게 된 거죠. Okay, so is this discrimination against women or discrimination against men? Woman. Man is, I mean, if you look at it from a dependent perspective, you may think that you may think that it is discrimination against men, but we are talking about how much the employer values the service, right? For male employee, for male uniform service employee, the government will value it so much, right, as to automatically accepting male dependents. But for female, the state will not automatically accept male dependent, right? Will demand something to be proved that there is actually a male dependent, right? So it is a discrimination against women. And on this, the court goes through the analysis as follows. The two paragraphs, the bottom paragraph, the bottom two paragraphs of page 699 Our nation has had a long and unfortunate history of sex discrimination. Traditionally, such discrimination was rationalized by an attitude of romantic paternalism, which in practical effect put women not on a pedestal, but in a cage. As a result of notions such as this, our statute books gradually became laden with gross stereotyped distinctions between the sexes. And indeed, throughout much of the 19th century, the position of women in our society was in many respects comparable to that of blacks under the pre-Civil War slave code. Neither slaves nor women could hold office, serve on juries, or bring suit in their own names, and married women traditionally were denied the legal capacity to hold or convey property or to serve as legal guardians of their own children. And although blacks were guaranteed the right to vote in 1870, women were denied even that right until adoption of 19th Amendment half a century later. Okay? So blacks were guaranteed right to vote in 1870, and only 50 years later, 1920, women were guaranteed the right to vote. It is true that the position of women in America has improved markedly in recent decades. Nevertheless, it can hardly be doubted that in part because of the high visibility of the sex characteristic, women still face pervasive and although at times more subtle discrimination in our educational institutions, in the job market, and perhaps more conspicuously in the political arena. Moreover, since sex, like race and national origin, is an immutable characteristic determined solely by the accident of birth, the imposition of special disabilities upon the members of particular sex, because of their sex, would seem to violate the basic concept of our system that legal burdens should bear some relationship to individual responsibility. And what differentiates sex from such non-suspect statutes as intelligence or physical disability and aligns it with the recognized suspect criteria is that sex characteristic frequently bears no relation to ability to perform or contribute to society. Finally, Title VII of the 1964 Civil Rights Act, which prohibited employment discrimination based on gender, Justice Brennan argued that Congress itself has concluded that classifications based on sex are inherently invidious, and this conclusion of a co-equal branch of government is now without significance. So the paragraphs I read are the reasoning behind raising the level of scrutiny for certain classification. Okay? So immutable characteristic, history of discrimination, and the congressional announcement. What else? There are 4. And no rational relationship to people's ability to contribute to the society. Okay? So for instance, discriminating between like minors and adults, that's easily justified because they have a different capacity to contribute to the society. But man, woman, black, white, right? Muslim, Christians, rationally, they don't have any difference in contributing to the society. So all those things put together in Franciero versus Richardson raised the level of scrutiny from rational based review to the intermediate scrutiny. Okay? Yes. Because Justice Brennan argued for strict scrutiny, but he didn't get the majority. He got only how many votes? I think he got only 1 vote for himself. Oh, no. He got only 4 votes. 9. And then there were 3 other justices who said they'll agree to intermediate scrutiny. Let's see.
So it stayed that way till now?
Yeah. Okay, four justices. Sperber, Blackburn, and there are 3 justices. And I guess there was a. Okay, so there are 4 other justices who agreed with the result, but on a different reasoning, right? So after that, they all settled on intermediate scrutiny. Okay. Let me read the important part there. If you look at the 3rd, 4th, 5th paragraph, so that's the large paragraph, like 5 lines, the last 5 lines. On the contrary, last like 10 lines. In any case, when we enter the realm of strict judicial scrutiny, there can be no doubt that administrative convenience is not a shibboleth, the mere recitation of which dictates constitutionality. Okay? So there can be no doubt that administrative convenience is not a shibboleth. So administrative convenience will never be a justification for gender discrimination. See, administrative convenience was good enough a reason for Beezer for discriminating against methadone users, right? But it will never be for discriminating women. See, that's how the level of scrutiny makes difference. Okay, any question, comment? We have 15 minutes. We're going to go back to Michael M. case. Yep. 네. 판례를 기점으로 아니에요. 그때부터 인터미디엇 스크루티니가 됐어요. 그러니까 그 이후로 한 번도 5명이 스트릭 스크루티니라고 동의를 해준 적이 없어요. 그러다 보니까 그냥 이 저스티스 브래넌이 포기를 하고 그냥 인터미디엇 스크루티니로 하자는 판례는 또 있어요. 근데 이거를 선택한 이유는 여기서 왜 레셔널 베이스 리뷰가 아니라 더 엄격하게 심사를 해야 되는지, 그러니까 왜 성차별은 더 강하게 보호해야 되는지에 대해서 설명이 여기 나왔기 때문에 이 판례를 보여드린 거예요. So, female adult and male adult Having sex between the two is okay. Minor. Having sex with a male minor is okay. Having sex with female minor, this is statutory rape. Okay. How about having sex between the two? Also statutory rape. 의제강간. So there was a constitutional challenge. Against the law, and we already established that this will be subject to intermediate scrutiny. Okay, what do you think about this?
Intermediate scrutiny was supposed to be applied for the discrimination against women, and this is now discrimination against men.
Well, that's what you should decide, whether this is a discrimination against women or discrimination against men. On the surface, it's the man who gets punished, but is it a discrimination against men? Or is it discrimination against women? What does the court think? Well, the same thing. I mean, where do you start in a constitutional question? Balancing. So the first question you ask is what?
What is the state's interest?
Yeah, what is the state's interest? What is the state's interest in banning, right? Banning. By the way, this is not just banned, but he gets punished, he gets punished. She is not. Okay? Now, what's the state's interest in punishing only male? But, you know, if the state really wants to prevent unwanted pregnancy, what's more effective? Preventing women from having sex, or preventing men from having sex? Or preventing girl from having sex, or preventing guy from having sex? What is a more effective way of fighting unwanted pregnancy? Anyway, but you said it right. So one reason is preventing unwanted pregnancy. That's one reason. Okay. Is there any other reason?
To protect girls from risky situations that might come from getting sexual
Okay. Risk of what?
risky criminal situations or risk of having sex.
Okay. So, real rape, right? Risk of real rape. Now, is that important enough to justify discriminating, punishing just men? Oops. What does the dissent say? I mean, just to correct, if you read the case, the majority relies only on this. It doesn't rely on, actually it denies that this is the state interest. If you read page 58, right, if you read the top paragraph, petitioners argues that the statute is flawed because it is based on the assumption it presumes that as between two persons under 18, the male is the culpable aggressor. Right? When you say there is a risk of real rape, you are presuming that male is the aggressor, right? That's why you will punish only boy, not girl, right? We find petitioner's contentions unpersuasive. Contrary to his assertions, the statute does not rest on the assumption that males are generally the aggressors. It is instead an attempt by a legislature to prevent illegitimate teenage pregnancy by providing an additional deterrent for men. Right? What is the additional deterrent for men? Well, going to jail. Okay? So, the majority is saying that, hey, if there's a pregnancy, a girl suffers anyway, so we don't need to punish her. But we need to provide some deterrent for minor. Right? So that's why we'll, discriminate man and woman. But Justice Blackmun, not Justice Blackmun, Justice Brennan, Justice White, Justice Marshall, they are the kind of the progressive bunch of the Supreme Court. What are they saying? Read read the first paragraph. Read the middle of the first paragraph. Assuming that prevention of teenage pregnancy is an important governmental objective, and it is in fact an objective of the statute, California still has the burden of proving that there are fewer teenage pregnancies under its gender-based statutory rape law than there would be if the law was gender neutral. Gender neutral means punishing both. or not punishing either, right? To meet this burden, the state must show that because it's a statutory rape law punishes only males and not females, it more effectively deters minor females from having sexual intercourse. So what the minority, what these justices are saying is that, hey, if you are serious about intermediate scrutiny, you better prove that this is more effective in fighting unwanted pregnancy. And if you go down the page, underlined part, common sense suggests that, hey, if it's that bad, punish them both, right? Why punish just one side and not the other, right? If buying and selling drugs is that bad, what do? You punish both, right? If bribery is that bad, you punish both the giver and receiver of bribery. Why are you saying that, just punishing male is more effective? You have to prove it. That's what intermediate scrutiny about. Rational basis review, you don't need to prove. This one, you have to prove. See, like in Brown versus Board of Education, they proved that segregation actually hurts people by doing experiments, right? That turned the decision. Here, same thing. Common sense suggests that punishing both is better deterrent. Why punishing just one side? Yeah, it may be easier to catch people because now one person can report, right? But administrative convenience, right? That's not enough to discriminate between man and female, male and female. Catching criminals is easier. That's not enough to justify discriminating males and females. And these justices later say, until recently, no California court or commentator has suggested that the purpose of a California statutory rape law was to protect the young woman from the risk of pregnancy. Indeed, the historical development of the statute demonstrates that the law was initially enacted on the premise that young women, in contrast to young men, were to be deemed legally incapable of consenting to an act of sexual intercourse. Because their chastity was considered particularly precious, these young women were felt to be uniquely in need of state's protection. In contrast, young men were assumed to be capable of making such decisions for themselves. The law, therefore, did not offer them any special protection. So the idea is that if a girl has sex, there is a more risk that it was forced upon her, right? So the law did not recognize female as self-reliant or self-sufficient sex partner as boy. Did not recognize girl as a self-sufficient sex partner as a boy is. That is the theory of the of the dissent, and Michael M. is the majority opinion in Michael M. is criticized roundly for this reason, and you will know why it is criticized if you read the last case which is Roskell versus Goldberg, page 719. This is the case where a woman filed a I think it's woman. 그러니까 시간이 없으니까 여러분 알아듣기 쉽게 빨리 우리말로 하자면은 징용을 하진 않지만 등록은 시켜요. 등록은 강제로 다 시키는데 등록을 남자만 하고 여자를 안 해요. 그거에 대해서 여성들이 소송을 제기했어요. 그러니까 징병을 위한 등록, 징병이 아니라 징병 등록을 해놔야 나중에 전쟁이 나면 곧바로 이제 데려갈 수가 있으니까 징병 등록을 남자들은 다 시키는데 여자들은 안 시키는 거에 대해서 여성 차별이다라고 해서 소송을 제기했는데 여기서도 이 마이클 M에서 합헌 판결을 쓴 판사의 판결문으로 또 이제 합헌이 나오게 됩니다. 그래서 그럼 여기서는 또 스테이트 인트레스트가 뭐냐? 이렇게 대규모 징병을 하는 이유는 전투병이 필요해서다. 그리고 전투병을 모집하기 위해서는 이 전투병을 모집하기 위해서는 여성까지 다 등록시키는 거는 administrative convenience. 돈과 비용이 너무 많이 든다. 그러니까 여성들까지 등록시키는데 돈과 비용을 낭비할 필요 없다고 본 거죠. 근데 이미 Reed vs. Reed, Frontier vs. Richardson에서 다 뭐라 그랬어요? 그런 비용 문제 때문에 차별하면 안 된다고 그랬거든요. 네. 그런데도 불구하고 합헌 판결이 나왔어요. 그러니까 지금 intermediate scrutiny의 어떤 실체를 좀 보여주는 거예요. 그러니까 실체를 보여준다. 내가 보는 실체를 얘기를 하는 거예요. 내가 보는. 내가 보기엔 이건 위헌 나왔어야 된다고 생각을 해요. intermediate scrutiny를 하면은 똑같이 해줘야 돼요. 특별한 공익을 성취하고 있는 게 아니면 왜냐하면 전쟁이 났을 때 여성은 할 일이 없는 게 아니잖아요. 그 전투병만 있는 게 아니잖아요. 그리고 더 이상 이제 뭐 전쟁을 하는데 실제로 뭐 주먹으로 싸우는 게 아니라 총이나 여러 가지 이 성별 차이의 중립적인 그런 도구를 가지고 싸우게 되죠. 이런 것들을 생각해 봤을 때는 이 전투병 모집을 위해서 여성만 등록하겠다라는 게 제가 보기에는 충분한 important governmental interest가 안 된다고 봅니다. 네. 자, 질문 있습니까? 이에 대해서? 더 크게. 소리가 잘 안 돼.
마이클 M 수업 관련해서 그냥 궁금한 게 있는데 미국에서는 여성에 의한 강간이 판결이 나요?
여성에 의한 강간이 그건 잘 모르겠네. 있을 것 같은데. 네, 다 있어요. 네. 네. 이 법이 내가 보기에는 좀 찾아봐야 되겠는데.
지금은 미국에서 미성년자가 남성 미성년자랑 그 성관계를 가지는 것도 의제 강간으로 되지 않나요? 그런 식의 좀 어떤
잠깐만요. 뭐 하여튼 알아보세요. 중요한 건 이 판결은 매우 비판받고 있는 판결이다. 네. 자, 더 질문 없으면 여기서 오늘 수업과 이번 학기 수업 마치도록 하겠습니다.